Morning, everyone. It's me again, Gershwell. I just wanted to advise you that the judge's briefing is still continuing. So if you'd like, in the interim, you could, stretch your legs. I would request that you remain logged in, but maybe you can take this opportunity to stretch your legs, maybe grab a cup of coffee, because we're due to return in about 10 minutes' time once we know that the judge's briefing is finalized. Thank you. Good morning, everyone, and thank you for joining us here today on this auspicious day. This is, of course, sorry about that. Just received a bit of audio feedback there, but let me start again. Good morning, everyone. My name is Gershwell Brooks. I'm the Communications Coordinator for the South African Human Rights Commission. And of course, I will be your Program Director throughout the course of today. Welcome to this, the grand finale of the National Schools Moot Court Competition. An auspicious day indeed. A very exciting day, and I'm sure that all of us are very excited to get the day going. I will ask very briefly that everyone please switch off their cameras and put themselves on mute until such time that you're called upon to speak or to participate. At this stage, I think it is appropriate that we start proceedings by asking everyone to stand if they're able to, whilst we listen to and perhaps even sing along with the national anthem. Thank you so much. That absolutely stunning listening to the national anthem and kicking off this auspicious event. But of course, as we know, that we wouldn't be if it weren't for the founding document of this constitutional democracy, and that is, of course, our constitution. And its preamble is extremely important because I think it lays the foundation for everything that we are about to witness today and participate in, as well as the very human rights that we speak of on a day-to-day basis. And to help us, or to remind us of the preamble of the Constitution is none other than Andisa Mulovedzi, who will give us a recital of the preamble to the Constitution. Andisa, the floor is yours.
We, people of South Africa, recognize the injustices of our past. Honor those who suffered for justice and freedom in our land. Respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representatives, adopt this constitution as the supreme law of the Republic, so as to heal the divisions of the past and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundation for a democratic and open society in which government is based on the will of the people and every citizen is equally protected by the law. Improve the quality of life of all citizens and free the potential of each person, and build a united and democratic democratic South Africa, able to take its rightful place as a sovereign state in the family of nations. May God protect our people. Nkosi sikeleli Afrika. Murena buluka sichaba sa Yesu. God sien South Africa. God bless South Africa. Mudzimu patuchedza Afrika. Osikatekisa I Afrika.
That, as always, a very moving rendition of the preamble to the Constitution. And with that, I'd just like to give you an introduction to, obviously, the participants, everyone that is here today, that we will be watching and will be arguing out the matter before us today. Of course, the bailiff will be taking care of the formal part of that aspect. And our bailiff this morning is Khalifa Shange, who you will hear from in just a few. However, prior to that, I just want to quickly give you an introduction to the judges as well as the teams participating this morning. First and foremost, I will start with our Chief Justice for this particular matter, and that is, of course, Chief Justice Margaret Victor. Madam Justice Margaret Victor will be the Chief Justice in this matter, followed by Judge 2, Mr. Hanif Vali. Judge 3 is Dr. Ashwani Budu, as well as Judge 4 being Miss Jackie Cassette. Judge 5 is Miss Fatima Laher. Judge 6 is Miss Rehana Khan Parker. Judge 7 is Advocate Shafi Amir Mia. Judge 8 is Advocate Andre Gaum. And then last but not least is Judge number 9 is Mr. JB Sibanyori, who will be presiding judges this morning. On behalf of the applicant, Team 115 or Team 115, that is Makedama High, is acting on behalf of the applicant, along with Mbwilwi Secondary, Team 216 or Team 216, rather. And that's on behalf of the applicant. On behalf of the respondent, we have Team 101, which is Mida High School. And then Team 214 or Team 214, which is Mowat Park High. Those two teams are representing the applicant this morning. Not the applicant, rather the respondent this morning. Of course, we wish all the teams well, and thank you to the judges for giving up their time on this Sunday morning to watch these very important proceedings. And just to give us a notion of how important the proceedings are this morning is, of course, we're going to be joined by the chairperson of the South African Human Rights Commission, that is Advocate Bongani Majola, who will be giving us the opening address this morning. Good morning to you, and I hand over to you, chairperson. Thank you.
Thank you very much, Program Director. I would like just to greet all the participants, but also to greet the Deputy Ministers of Basic Education and the Department of Justice, and thank them for walking this road with us all the time. I would like to also greet our judges and thank them for sacrificing their time. It's not only for the love of the kids that are participating here, but it's also for the love of our country, because the purpose of this moot court competition is actually to create a culture of human rights in the country. To the competitors themselves, I'd like to say hello to you too, and to welcome you to this final, and to congratulate you for having gone up the ranks and today competing for the final. I know that there may be parents and friends and relatives watching. I'd like to say hello to them and to greet them very warmly this morning. And friends of the Commission, friends of the Department of Justice, friends of the Department of Basic Education, friends of the Center for Human Rights, I would also like to say to you and to our colleagues in the various entities, good morning. It is indeed, of course, a pleasure to hold this final of the National Schools Mood Competition this year. Due to the coronavirus, excuse me, and the declaration of the national state of disaster in March 2020, it became impossible for us to hold the competition in that year. As we all know, schools were closed for most of the time. Movement and large gatherings were restricted, and there were many other limitations of human rights that were necessitated by the state of disaster. Besides, many were affected by the virus, of whom some became seriously ill and even lost their lives. And we really regret that and sympathize with their families. Digital communication methods were still underdeveloped at the time. Besides, poverty was also a factor denying poor learners the opportunity to continue participating in their own education. While therefore we recognize the loss that we have had in terms of the opportunities for schools mood competition, I think that we should not forget the devastating impact that the coronavirus has had on learning and on our lives generally in 2020 and 2021. And as a commission, we would like to urge everybody to consider taking COVID-19 vaccination, because it is shown scientifically that it helps protect people who get infected by the virus from getting severe disease or even dying. And I hope that we can all consider how important it is for us to continue living and continue doing the work that we are doing, and not expose ourselves to the risks of being infected and even being disabled by this virus. All of us are therefore extremely pleased today that it has been possible to hold the National Schools Moot Court competition this year, albeit with severe restrictions, as you can see. The fact that we have spent the whole week holding the competition and that we're doing the finals today is extremely encouraging. It is clear that while there is a place for digital technology in our education system, we are gradually getting back to the state of normality. One hopes that the efforts to achieve herd immunity will soon bear the desired fruit, so that the learners especially can go back to class and all of us can return to the normal ways of doing things. While the finals are happening virtually this year, it is our hope that the whole competition will be done face-to-face next year and the years thereafter. The South African Human Rights Commission is privileged to be hosting the competition and to be one of the pillars that support it. The other pillars, of course, being the Department of Basic Education and the Department of Justice. Of course, the continued support of the Center for Human Rights at the University of Pretoria remains invaluable, which reminds us of the sad loss of the true champion of the Schools Moot Court competition, the late Professor Christoph Haynes. He was a man of incredible vision and love for the promotion of human rights in a practical and tangible sense that we see in this competition. The involvement of the South African Human Rights Commission happened because of his own vision. When he approached us, he said that this falls naturally within the mandate of the South African Human Rights Commission, and suggested that we take the lead in managing it and organizing the competition each year. So even though we didn't have a budget for it at the time, we saw the importance thereof and we made means. I'm grateful to the other partners who also readily agreed to the suggestion that we be part of this important initiative. Christoph Haynes was passionate about the competition as he was passionate about everything else, and used to say to me that the nature of the competition not only introduces learners to and educates them about the Bill of Rights, but also raises awareness in the whole family and even extended family and acquaintances of the learner and her or his family. This is so true. His vision, therefore, plays a significant role in the implementation of the mandate of the Commission to promote and protect human rights in this country and to create a culture of human rights. His philosophy is that if we are to help create a culture of human rights in this country, we need to educate the youth. And the youth, that is critical for the culture of human rights in the future. And the Commission will cling to this philosophy for as long as this mandate requires it to develop a culture of human rights. Now, let me address all competitors briefly. Congratulations for battling the odds imposed by the coronavirus and the state of disaster, and for participating in this competition. In a way, it signals that life always will be full of challenges, even though not always challenges of such magnitude as the coronavirus. But the fact that you have braved the odds is highly commendable. Success in life comes to those who face the odds. South Africa won the moot court competition last year at the international level in 2019, not last year, in 2019, which signified that we have talent and that we can reach the stars. Today is your opportunity to do so, and I would like to wish you luck. Finalists should know that each team will do its best and that all teams are winners in this competition. Some will win in terms of what the judges say, but all of us, or all of you, will be winners in the sense that there is a lot that you will gain from this. And I tell you that after some years, you'll look back to this day and you'll remember that I said there is a lot that you will be gaining, walking away with from this competition. And thank you for participating. Listen, mine is not to give a vote of thanks. However, let me conclude by thanking all the panel members who will be judging this final and thank them for selflessly giving of their time to the education of our youth, the leaders of tomorrow. May I also express gratitude to the two departments for all the resources they have spent in supporting the competition, particularly in stages that build up to this competition, this final. I know that there are other volunteers, and I thank them, including parents especially, of all participants for supporting this very important initiative. Finally, I would like to say thank you to all our colleagues and all the other supporters for supporting this initiative, and to wish participants and judges alike the best for today. Thank you.
Thank you for that, Chairperson. I really do appreciate your words of encouragement, especially for the competition that is about to commence. But of course, with that, we have an address by none other than Honourable Deputy Minister of Justice and Constitutional Development, and that is Mr. John Jeffrey himself, who will be giving us our main address this morning. Good morning to you, Deputy Minister. The floor is yours. Thank you.
Good morning, Gersh. And good morning, everybody. Can everybody hear me okay? Can you hear me?
Yes.
Yes,
Can you hear me?
Minister, we can hear you.
Okay. So good morning, everybody. Program Director Gershwin Brooks, our esteemed panel of judges, members of the judiciary, the chair of the Human Rights Commission, Professor Majola, and commissioners, Professor Frans Viljoen and representatives from the Center for Human Rights, participating learners, their educators, principals, and family members, distinguished guests and friends. It's always a pleasure to be able to attend this exciting and prestigious event, an event that I've been privileged to be part of for many years. Human rights and constitutional education are a fundamental part of our democracy. People can only enforce their rights if they know their rights. That's why we're so pleased that this competition is going from strength to strength. The first annual National Schools Moot Court competition took place in the Constitutional Court on Human Rights Day in 2011. So it's 10 years now. It turned out to be a groundbreaking event, and we can really look back with pride over the past 10 years when we acknowledge the success of this competition and its participants. As Professor Majola has done, I want to acknowledge and pay tribute to the late Professor Christoph Haynes, who sadly passed away in March this year. Christoph was a pioneer of this competition. He was passionate about human rights education, and how proud Christoph would have been if he were here with us today. This competition aims to create greater awareness in schools and communities in South Africa about the Constitution and the values that it embodies through active participation. The aim is also to further encourage talented young people to consider pursuing a career in law. This competition provides a unique opportunity for learners to develop their research, writing, and oral advocacy skills as they endeavor to come to grips with some of the constitutional issues that are presently facing our country. Moot court competitions have many benefits and allow learners to improve their public speaking, learn to structure a legal argument, analyze cases, and further develop their writing skills. Human rights education is extremely important, not only in our country, but indeed the world over. As the former UN Secretary General, Kofi Annan, said, and I quote, "Human rights education is much more than a lesson in schools or a theme for a day. It's a process to equip people with the tools they need to live lives of security and dignity." The world also faces increasing challenges of poverty, inequality, climate change, and now also COVID-19, to name but a few. And these are all challenges which can stand in the way of or diminish the gains we've made in the attainment of people's human rights. And that is why human rights education is vital. In your hypothetical case, we've gotten to know the Mjondolo Combined School, its learners, Sfiso, Tato, Apiwe, Crystal, Eddie, Mbali, and Precious. And of course, last but by no means least, Ms. Khoza, also known as the General. Without giving too much away or influencing any of the arguments, it's important to note that the case highlights a number of constitutional rights and how these rights interplay with each other. What is important is that constitutional rights have to be weighed up against each other, something which our Constitution provides for by way of the limitations clause in Section 36. Simply put, my rights are not unlimited if they negatively affect or infringe on your rights. This requires a delicate balance of competing rights, and we see this in our daily lives every day. For example, a person may have the right to freedom of speech, but must exercise it in such a way that it does not infringe on another person's rights to human dignity or amount to hate speech. Someone may exercise their right to freedom of religion, belief, culture, and conscience, but not in a way that unfairly discriminates against another person on the basis of their race, gender, sexual orientation, language, or any other of the grounds listed in the equality clause in the Constitution. This weighing up of competing rights is something that the South African Human Rights Commission, who is hosting this competition, has to consider daily in the work it does. For example, in 2016, the Commission had to investigate the challenge of how protest-related action can impact on the right to basic education. In April 2016, the Limpopo High Court handed down a judgment confirming the community-contested demarcation by the Municipal Demarcation Board that incorporated Vuwani district into the Malamulele municipality. Dissatisfied with the order of the High Court, some residents embarked on protest action, which resulted in 29 schools in the area being set alight, allegedly by protesters. According to information from the Department of Basic Education, the burning of the 29 schools disadvantaged an estimated 10,233 learners. The total number of schools disrupted was 102, with 52,827 learners unable to attend school. This had a devastating impact on learners and resulted in the Commission undertaking a national investigative hearing into the impact of protest-related action on the right to basic education in South Africa. In our democratic South Africa, considerable attention has been paid to ensuring that a wide section of society achieves basic education. According to a report released by Statistics South Africa earlier this year, more than half, and that's 62% of the child population aged 0 to 17, lived in low-income situations, and children in female-headed households were more likely to live under these conditions. More than 2/3, that's 68% of children aged 0 to 17, received the Child Support Grant in 2018. Some 76% of children under 18 years of age lived with their biological mothers, while 36% lived with their biological fathers. South Africa has very good education policies which guarantee universal access. While near universal attendance and completion of primary education was recorded, grade repetition, especially amongst male learners at primary school, remains a challenge. South Africa's effort in expanding children's access to education has benefited school-age children, as close to 99% of children aged 6 to 13 and 96% of children aged 14 to 17 attended school. However, regional inequalities as well as population group inequities in school attendance still persist amongst children in South Africa. As the South African Human Rights Commission has stated, the right to basic education is key to South Africa's development. South Africa comes from a history of exclusion of a large section of its population, where quality education to the majority of the population was systematically denied. The 1976 student uprising drew attention to the unequal education standards that existed in the country, and protesting youth sought to challenge that. There was a realization then, just as there still is today, of the fundamental importance of education in lifting society out of poverty and inequality. Ladies and gentlemen and learners, I would argue that the future of our democracy is further enhanced by the caliber of learners and their participation in this competition. I would also like to express our sincere thanks from the side of government to all stakeholders who've assisted in making this competition so successful. I also want to congratulate everyone who's participated in this year's competition. We know and appreciate the hours and hours of preparation and the hard work by learners, their educators, and their parents who supported them. To the learners, I hope to see many of you in a few years' time in the legal profession, in our courts as prosecutors, as legal researchers and academics, and in a few more years after that on the bench, as you've shown that you have the talent and the passion and hard work, that there's nothing that can hold you back. I wish all of you the very best of luck, and you can be extremely proud of what you've achieved thus far by
Thank you, Deputy Minister. Thank you for your key address this morning. And that brings us immediately one step closer to, of course, this prestigious event and this competition this morning. And as we would in court, we immediately hand over to the bailiff, who will then take care of proceedings from this point forward. I call upon the bailiff, Khalifa Shange, to introduce the matter before us today. Thank you.
In the matter between Precious and 5 others, appearing as the applicants, and Mjondolo Combined School appearing as the respondent, the Constitutional Court is now in session. Chief Justice Margaret Victor and the Honorable Justices, Mr. Hanif Veli, Dr. Ashwani Padu, Ms. Jackie Cassette, Ms. Fatima Leah, Ms. Rihana Khan Parker, Advocate Shafi Amir, Advocate Andre Gaum, and lastly, Mr. JP Sibanyoni presiding. The applicants and the respondents are each allocated 20 minutes to present their arguments. Thank you.
Right, council may mention their appearances, first the applicant and then the respondents. Counsel for applicant.
My justices, may it please the court, I am Boibusi Siwe, and together with my co-counsel Ntutu Kondlela, we appear before this honorable court on behalf of the applicants. We intend to present.
Thank you, counsel. If I could just have the representation by the respondents, they announce their appearances.
As it pleases the court, I am Aluso Luata, appearing on behalf of the respondents with my co-counsel, Mr. Njongwe.
Thank you, counsel. Right, counsel for applicant. Before you commence, I'm going to just describe the usual rule in the Constitutional Court. We will give you 5 minutes where our justices won't interrupt you, and then after that, the justices are free to question your argument. Just unmute yourself, please.
May I begin? My justices, we intend to present to this honorable court 3 submissions, in which the first and the second are the prayers, and the third is an alternative submission regarding that the fact that the Schools Code of Conduct, Section 4 of the Schools Code of Conduct, should be struck out, as it is not a rule of general application and it is applied arbitrarily by the school. My justices, Section 4 of the Schools Code of Conduct states that, and I quote, "The use of cell phones, whether on or off on school premises, shall at all times be prohibited. Any learner that is found in possession of a cell phone shall have that phone confiscated and may be suspended." The effect of the Section 4 of the Schools Code of Conduct is that, or the fact that the Section 4 of the Schools Code of Conduct essentially grants power to the school to search the bags of all learners at random and without notice. The effect of this rule is that it infringes upon Section 14 of the Constitution, where it is a right granted by the Constitution, which states that everyone has the right to privacy, which includes the right not to have their property searched and possessions seized. The fact that, my justices, we submit that the search conducted on the learners and the confiscation of their cell phones was an infringement to this right. For privacy is a fundamental right essential to autonomy and serving as the foundation upon which many other human rights are built. And cell phones have increasingly become more central to the intimate personal sphere of the life of human beings, for they contain calendars that plan our days, apps that are capable of sharing sensitive information, and apps that track fertility and reproductive details of the users. Well, in this case, it's for females. My justices, losing a cell phone, or worse, having it confiscated, takes away the owner's access to all of this. It takes away the owner's access, or the owner's autonomy, and arguably their dignity as well. A right granted by Section 10 of the Constitution. A rule such as this one that infringes upon autonomy, dignity, and the right to privacy is surely unconstitutional. In the following cases, the Anthony versus Governing Body, MEC of Education versus Pillay, and the Tinker versus Denmans, the court consistently interpreted a learner's alleged breach of the school's rules in terms of causing disruption and order of the school. Therefore, there is no reasonable conclusion that can be drawn that a learner in possession of a cell phone can cause disruptions in the school's activities. My justices, I would like to remind this honorable court of Section 28, subsection 2 of the Constitution, which informs us that a child's best interest are of paramount importance, and the applicants are all below the age of 18. We saw how when these learners, the applicants, were found in possession of a cell phone, they were immediately suspended for the rest of the year. This infringes or goes against Section 9, subsection 1, paragraph A of the South African Schools Act, which informs us that subject to this act and any applicable provincial law, the governing body of a school may, after a fair hearing, suspend a learner as a correctional measure for a period not longer than 1 week. And these learners were not given a chance to a fair hearing, and neither were they suspended according to Section 9, subsection 1, paragraph A of the South African Schools Act.
My justices, I'll now like to move to the second submission of the applicant's argument.
Counsel, your protection time has elapsed, so I'm going to allow my co-justices to put questions to you. Right?
Thank you very much.
Thank you. Thank you.
Thank you very much, Madam President. Through you, counsel for the applicant, I have a question. So you're mentioning the Schools Act of South Africa, and you're talking about how the best interest of the child should be preserved. But in this particular case, if you look at the facts, the steps taken by the state have indeed led to higher pass rate at the school level. Don't you think that is also in the best interests of the child?
My justices, there was a case in which we were informed that both discipline and education are legitimate goals. However, care must be taken not to take the school's interest too broadly. My justices, yes, the implementation of the school's code of conduct did bring about a greater increase of their marks, but instead, the school's code of conduct infringes upon the learner's rights to privacy and basic education, which makes it not constitutional, for they could have found less restrictive measures.
Thank you. Any further questions?
May I ask the following question? You mentioned that this section 4 does not constitute a law of general application, but it is quite clear that in terms of the South African Schools Act, schools are indeed required to put together a code of conduct, and that code of conduct must, in terms of the Harmony High School case, be aimed at establishing a disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process. So doesn't that make of this code of conduct and section 4 of the code of conduct indeed a law of general application?
My justices, we are all aware that Section 36 of the Constitution informs us that the rights in the Bill of Rights may be limited in terms of law of general application to the extent that the limitation is reasonable and justifiable in an open and democratic society. My justices, being that the school says the cell phones following a rule, and it being true that the rights in the Bill of Rights may be limited, it is also true that the rights in the Constitution must be limited by that a rule that is of a general application. Yes, it might be, you consider it to be a rule of general application. But my justices, the question should be asked whether the limitation to privacy does pass the limitation clause. And it doesn't for the relation between the limitation and its purpose. We understand the aim of this rule is to enforce discipline and to improve the school's results. But although the school's results have improved, there's no direct correlation between lack of privacy and improved marks. Learners who choose to bring their cell phones could put them in their bags and choose to listen in class, but certain learners could leave their cell phones at home but choose not to pay attention in class.
Thank you, Counsel. I think there's one more question from Justice Khan Parker.
Thank you, Judge President. Thank you, Counsel, very much. I've heard your argument with regard to Section 9, 10, and 14, and you've just answered the one question that I wanted to ask with regard to 36.1 being the limitation of rights. However, I note that you've not addressed us on the Article 21 at all in relation to how it will play out against Section 9 being equal before the law. Thank you.
My justices, are you referring to Article 1 of the United Nations International Covenant on Civil Rights and Political Rights?
I'm referring to the right of peaceful assembly as contained in Section 17 and how that relates to being equal before the law in terms of Section 9. Thank you.
My justices, for you are referring to the right to peaceful assembly. I'm afraid I'll just briefly explain upon it, since my co-counsel Ntutuko will deal with the right to peaceful assembly. But we are all aware that the applicants were not found to violate anything, or when they were not found to be the ones who caused the distractions, blocked or caused the fire at the administrative block. And Article 21 states that an individual does not cease to enjoy the right to peaceful assembly as a result of sporadic violence or other punishable and committed acts by others in the course of the demonstration, if the individual in the question remains peaceful, his or her own intention of her behavior. And the applicants, who are the 6 learners in this case, they were not proved to have caused distractions or community disruptions or actually caused the fire.
Thank you, Council. I'm going to ask you to round off now. Anything further that you want to submit?
My justices, I'll submit the before concluding, I'll submit the Western High Court, Anthony Bass's governing body, Settlers High School, where the question was asked that the question should be asked in this regard, whether or not the prohibition is aimed at promoting positive discipline, or whether or not non-compliance therewith justifies punishment or some other form of sanction. This requires a spirit of mutual respect, reconciliation, and tolerance. The mutual respect, in turn, must be directed in understanding and protecting, rather than rejecting and infringing the inherent dignity of the offender. My justices, it is apparent that the cell phones in this manner does not reject or infringes, or the confiscation of cell phone rejects and infringes on the applicant's inherent dignity, and therefore the rule fails to meet the requirements of Section 36 of the Constitution. My justices, I would now like to hand over to my co-counsel.
May I come in, please?
Your co-counsel. Are we not going to have the respondent first? Lead counsel for the respondent.
So, Justices, will it not be the second speaker for the applicant before the respondent?
I just thought that perhaps the second speaker would be in reply. But let's then stick to the order, and if it's the second counsel for the applicant, co-counsel, please, you may.
As the court pleases, I am Dusuan Lela, second counsel for the applicant, and I'll be dealing with the second part of our argument, which is our third submission, which is the protest of the learners. After the learners were suspended from the school.
Before you start, how many minutes have you allocated, has your team allocated to your address?
I think it's 10 minutes, 10 minutes.
Right, thank you. You may proceed.
As the court pleases, I'm Dutua Ndlela, second counsel for the applicant, and I'll be dealing with the second part of our argument, which is our third submission, which deals with the protest of the learners. Your justices, after the learners were evicted from the school premises, they decided to protest outside the school gate. In doing so, they were merely exercising their right to freedom of expression, which is Section 16 of the Constitution. And its subsection 1 states that everyone has the right to freedom of expression, which includes the right to receive, impart information and ideas. And also, if we look at Section 17, it is assembly, demonstration, picket, and petition. And it states that everyone has the right to peacefully and unarmed to assemble, demonstrate, picket, and present petitions. With that said, your justices, we submit that the learners were justified in protesting as they did, as it was the only way that they were able to express how they felt towards the unfairness of the situation, and also they had the right to present the petitions as they did, as it was the only outlet that they could use. In the case of South African Transport Allied Workers and Others versus Govers, which was in 2013, which was ruled in the Constitutional Court, in paragraph 61 reads that the right to freedom of assembly is central to our constitutional democracy, as it exists primarily to give a voice to the powerless, which includes groups that do not have economical or political power and other vulnerable persons, as it provides an outlet for their frustrations. Therefore, my justices, we submit that the learners are also justified in protesting, as it was the only mechanism that they could use in order for the school to adhere to their frustrations and also act. And as the school was also politically and economically vulnerable in compared to the school. Your justices, we also submit that the learners' protest was peaceful in terms of Section 17, which is peaceful assembly, demonstration, pickets, and petitions, as there were no attributions that linked the 6 learners to the violent parts of the protest. And if we look at paragraph 53, it states that, and paragraph 53 in the Governors case, it states that an individual does not cease to enjoy the right to peaceful assembly as a result of sporadic violence or any other punishable acts committed by others in the course of the demonstration if the individual in question remains peaceful in his or her own intentions or behavior. With that said, my justices, we submit that we must not hold the learners liable for the violent parts of the protest, because it could have been committed by the other learners who decided to join the protest. As far as we know, the learners had peaceful intentions. Also, your justices.
Are those rights, Council, are those rights absolute? The rights you mentioned in the Constitution, are they absolute?
As the court pleases, thank you for the question, my justice. And the answer says no, they are not absolute, as they can also be limited. But we must also look into consideration if the limitation is justifiable.
Right, thank you, Council. Further questions from my co-justices?
Yes, Madam President. Council, can you please elaborate a little bit about why we should still uphold the right, even if they did not give any notice before the gathering, according to the regulations of Gatherings Act?
Thank you. As the court pleases, thank you for the question, my justice. If we look in the case of Mlungwana, it was concluded that the rights to give the section 12, which is the offenses and penalties for failing to give a notice, is unconstitutional because it violates the learner's right in terms of section 28, which is in the best of the interest of the child.
Right, Council, can you deal with remedy briefly? What do you submit the appropriate remedy is?
My justice, may you please rephrase your question?
This court has to give an order. And what is the order that you seek? If you could justify why you seek an order that it be set aside, the decision of the governing body.
Or the decision of the governing body for suspending the learners.
Yes, and perhaps you can refer to case law on the question of suspension and setting aside a decision.
That question leads to my second part of the argument, my justice. So the suspension of the learners was also unconstitutional, as it was unfair, because if we look in the school failed to apply the principle of audi, which is the right to hear the other side. Now, if we look in the case of Swisocele, the Swisocele was given an opportunity to a fair hearing, but then if we look in the 6 learners, they were not given an opportunity and they were not given a fair hearing to justify their actions. With that said, my justice, which also leads to another issue, which is now equality and no democracy, no democracy, my justice.
Right.
Madam President, may I ask, if we look at the protest before the meeting that was called of the school governing body, the one where Eddie sent the WhatsApp message to Crystal and Bali, and there were 40 learners, and they actually blocked the entrance to the school. The meeting could not take place, and then the one the next morning with 100 learners, where they made it impossible for students to gain access. Wasn't this a matter then of, whilst they could not be linked to protest action that was not peaceful and armed or something like that, they were indeed linked to a violation of the right to a basic education. So they acted in a manner that actually impeded upon the right to a basic education, and that therefore the governing body acted justly in the suspension.
Thank you. As court pleases, thank you, my justice, for the question. As the court pleases, our submission is that although the learners protested, the SGB was still wrong in suspending them without a fair hearing. And there's also suspending them, which was also limiting these learners' rights in terms of Section 29, which is basic education, and it is the access to basic education. Because my justices, if we look in the case of head of Department of Education, Free State Province versus Welcome High, and another, it was decided that suspension is unconstitutional as it also violates the learners' rights to basic education. So with that, my justice, we submit that the SGP's decision was also unconstitutional because it also violated these learners' rights in terms of basic education, and since they were not given a chance to catch up with their schoolwork as they were left out, as they were suspended.
Thank you, Counsel. I'm now going to ask Justice Valley to ask a question.
Thank you, Chief Justice. Counsel for the applicants, there are two issues here, and you've addressed the issue of peaceful assembly. You haven't been clear on the issue of why is the School Code of Conduct Section 4, specifically related to cell phones, unconstitutional. You've talked about a basic right to education linked to not using a cell phone in the school or bringing a cell phone to the school. Why is Section 4 specifically relating to cell phones unconstitutional in terms of which rights? Thank you.
Thank you for the question, my justice. I'll not be deeply in this because the first counsel was mostly dealing with the Section 4 of the School Code of Conduct, violating the learners' rights in terms of Section 14 and 29. My justices, Section 4 of the School Code of Conduct states that the use of cell phones, whether on or off, by learners at a school shall at all times be prohibited, and any learner that is found in possession of a cell phone may have the cell phone confiscated and may be suspended. Now, Your Justice, if we look into Section 4 of the School Code of Conduct, that maybe highlights that there must be a procedure that must be followed when dealing with the process. There must be a fair hearing that is conducted before the learners are fully suspended. Therefore, Your Justice, we submit that the SGP's decision, also the School Code of Conduct is not clear to terms if also the extent of the suspension, because it just says that the learners may be suspended, but it's not clear for how long the period must be for the learners to be suspended, and also that there must be a process to be followed, which was not by the school governing body.
Thank you, Counsel. I think there's another question from Justice Gao. Justice Gao, if you could unmute yourself. I saw your hand up.
Yes, thank you very much. Can you indicate to us in terms of because let's say we accept there is a limitation of certain rights, including the right to a basic education and so on, and privacy by Section 4 of the School Code of Conduct. Can you indicate to us whether you think there would be less restrictive means to achieve the purpose of discipline than Section 4 of the Code of Conduct? Thank you.
Thank you for the question, my justice. My justice, we therefore submit that there could have been less restrictive measures that could be applied to make sure that Section 4 of the School Code of Conduct is abided by, because the learners could have brought the cell phone to school for different purposes, maybe safety purposes, and also maybe if they wanted to keep contact with their parents when they were leaving school, because we cannot ignore the criminalities that we face nowadays. There's kidnapping, hijacking, all of those things. Therefore, we cannot ignore the fact that the learners could have brought the cell phones to school for other different purposes that are also important.
Right, there's still a few minutes left, my co-justices. Any further question?
May I just come in, Madam Chief Justice, and ask the applicant here in relation to the interpretation of the Bill of Rights in terms of Section 39(1)(b), which says, when interpreting the Bill of Rights, a court, tribunal, or forum must consider international law. Can you address that in line with the United Nations Convention on the Rights of the Child, in particularly the Code of Conduct vis-a-vis Article 15 of the United Nations Convention on the Rights of the Child, and the infringement of your rights as the applicant in this matter?
My Justice, if you could kindly rephrase your question.
Can you address the court on the United Nations Convention on the Rights of the Child, Article 15, vis-a-vis the Section 4 of the Code of Conduct, and the infringement of those rights that you have so articulated before the court?
Thank you for the question, my Justice. As the court pleases, if we look at Article 15 of the United Nations Convention on the Rights of the Child, which is CRC, its Article 15 states that no restrictions may be placed upon the exercise of the rights of the child, which is freedom of association and freedom of assembly. No restrictions may be placed on the exercise of the rights other than those imposed in the conformity with the law and which are necessary in a democratic society in the interest of national security or public safety, public order, the protection of public health or morals, or the protection of freedom of the rights of others. Therefore, my Justice, we submit that the learners' protest was justifiable since it did not violate any other rights, as a protest, if we define a protest must be disruptive in order for it to achieve its purpose. Because as far as you know, in order for a protest to see that the protest is working, there must be a disruption so that the people who are protesting must be adhered and must be heard for their concern. But we must also consider that this protest was peaceful in any way, and no other learner that was not in the protest got harmed during their protest, and no learner lost their life.
Thank you, Counsel. Any further questions? From our
Justice, sorry.
Right. Justice Valley, do you have another question?
Yes, sorry. I just wanted to give the first counsel for the applicant the opportunity. Apparently, she had prepared on the issue of how Section 4 of the Code of Conduct impacted on the Bill of Rights. Which particular rights are you arguing it had impacted on, and why do you say that?
Right, lead counsel, first counsel, if you could respond, unmute yourself.
My Justices, we submit that Section 4 of the School's Code of Conduct is unconstitutional because it infringes upon privacy, which I've stated before that privacy is a fundamental right essential to autonomy and acting as the foundation upon which many other human rights are built. And it is directly linked to human dignity, which is a right granted by Section 10 of the Constitution. And a right which limits upon or infringes upon human dignity cannot be considered as constitutional, for we have to keep in mind or bear in mind Section 2 concerning the supremacy of the Constitution, which states that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled.
Thank you, Councillor. Any further questions?
I'm just trying to understand. Privacy has got a number of different elements. What are you arguing with in the right to privacy as being objectionable in respect of Section 4. This is still the lead counsel.
May you please rephrase your question?
My question is, the right to privacy has got a different elements, person's home or a house, or their person being searched, their property being searched, etc. What particular in the section, what particular aspect of the section are you objecting to as being infringed by Section 4 of the School Code of Conduct?
My justices, this is about the right to privacy being infringed upon, which is in that is granted by Section 10, as well as basic education regarding
what? Sorry, I beg your pardon. I'm sorry to interrupt you. What specifically in the right to privacy are you objecting to?
My justices, a test of the limitation clause. The question should be asked whether the limitation to the right to privacy by the school's code of conduct passes the limitation clause. Firstly, the nature of the right. We all know that the nature of the right that is being limited by this rule is a right that is directly linked to dignity and autonomy. Secondly, the importance of the purpose of the limitation. The purpose of the limitation is to enforce discipline in the school. Thirdly, nature and extent of the limitation. The limitation is one that takes away the owner's autonomy and dignity of the learners, as their cell phones that contain personal and sensitive information is taken away. The ability to communicate, make financial transactions, make their day-to-day lives, and use internet resources for educational purposes is infringed upon. Therefore, this limitation cripples their lives of modern age. Fourthly, the relation between the limitation and its purpose. As I had said previously, the aim of the rule is to enforce discipline and improve the school's results. Although the results have improved, there is no direct correlation between lack of privacy and improved marks in Njondolo Combined School. Less restrictive measures to achieve purpose. My justices, they could enforce detention on learners that are found contravening the school's code of conduct instead of suspending them, which violates Section 9, subsection 1 of the South African Schools Act.
Thank you, Council. Perhaps Bailiff can indicate how many more minutes we have for this section. Bailiff?
Zero.
Yeah. Right. So now it's, thank you very much, Council, for the applicants. It has been most encouraging. Advocate, Justice Gaum, I still see your hand up. And
yeah, but I see our time is, if you rule that our time is up, then it's okay.
I'm going to rule that is it now time for the respondents to take to the podium and address the justices? Right, Counsel for the respondents, you may unmute yourselves.
As it pleases the court, I am Alutho Luata, and I will be appearing on behalf of the respondent with my co-counsel, Mr. Njongwe. I will be addressing the constitutionality of the School's Code of Conduct, Section 4, leaving my co-counsel to address the constitutionality of the SGB's decision. We refer to the state of fact, stating that a code of conduct was implemented to regulate the use of cell phones. In respect to this implementation, paragraph 184 of the Pillay case that was ordered by the Constitutional Court in year 2008 states that encouraging the observance of rules is the first step to establishing civility in that institution. Paragraph 58 of Head of Department of Education, that was ordered by the Constitutional Court in year 2014, stipulates that a code of conduct must be aimed at establishing a disciplined and purposeful school environment. We state that is exactly what the respondent was trying to achieve, as Ms. Koza states in the facts that we need to get discipline back into our school. We put into great aspect the importance importance of abiding to a school's code of conduct, as Section 8, subsection 4 of the Schools Act states that nothing contained in this act exempts a learner from the obligations to comply with the school's code of conduct that is attended by such a learner. Counsel for the respondent refers to the state of facts that states that emphasizes that many of the learners and educators of this school agreed with the need for greater discipline. This goes to show that it wasn't the school alone that made a decision for improvement, but rather we submit that many members came together democratically and pleaded for change. This goes to show that the respondent adheres to Section 8 of the Schools Act that stipulates that a code of conduct may be enforced after full consultation. Therefore, with this submitted about the consultative, your justices, we state that if the courts are to rule that the respondents were guilty of an offense, it would also be ruling that many of the learners and educators who push for a change are all guilty of an offense. The functions of the school governing body, according to Section 20 of the Schools Act, are to promote the best interest of the school and learners alike by implementing a school's code of conduct and also ensuring the development of quality education. We refer to paragraph 62 of the Pillay case that states that a governing body is akin to a legislative authority within the public school setting. It is responsible for the formulations of regulations in order to guide the daily management of the school and to ensure an appropriate environment for the realization for the right to education. Your justices, in the case of head of Department of Education, Free State Province versus Welcome High School, ordered by the Constitutional Court in year 2013, it states that the right to education can be limited in terms of general application, in according to Section 36 of the Constitution. As a result of this case alone, we submit Section 36 of the Constitution, specifically subsection 1B, that deals with the importance of the purpose of the limitation. We submit, your justices, that it was important to limit the right to basic education in this term, as the school is also responsible for every single learner that is in the school, including those who did not bring their cell phones and were deprived of their right to basic education, as teaching and learning could not take place. Lastly, to prove that Section 4 of the School's Code of Conduct does not infringe on the applicant's right to basic education, we refer the courts to the state of facts, page 1, paragraph 1, indicating that instead of paying attention in class, these learners would use their social medias and teachers would find it hard to teach under these circumstances. Your justices, the question before the courts is whether the applicant still applied basic education in these terms. We submit, your justices, that if the respondent did not implement a code of conduct, the applicant would not even practice their right to basic education, and in fact would actually limit the rights of others. Your justices,
Counsel, your protection time is over. So now the justices may ask you questions. Thanks for that.
Madam Chief Justice, may I?
You may go ahead,
Thank you.
Justice.
Thank you very much. Counsel, can you address the court on the issue of South Africa has ratified 2 international conventions, that is the United Nations International Covenant on Civil and Political Rights, Article 21, and also the United Nations Convention on the Rights of the Child, in particular Article 15. Would you address the court and say to us whether your code of conduct is in line with these international obligations read together with Section 39(1)(b) of our Constitution, which talks about the interpretation of the Bill of Rights? And it says that when interpreting the Bill of Rights, a court, tribunal, or forum must consider international law. So the point is, has the school adopted the international law principles when you formulated your code of conduct? Please address the court. Thank you.
As it pleases the court, one of the main requirements of these articles is peaceful assembly. Your Justices, we submit that in accordance to the state of facts, these protests that occurred outside the school gates were not peaceful, Your Justices, and therefore they were unlawful. And therefore the applicant in this right loses its constitutional protection.
Thank you. Advocate Valley, Justice Valley, and thereafter Justice Gaum, and then Justice Jackie Quisette.
Thank you, Chief Justice. Counsel, do you think that the school governing board's decision to suspend 6 students for the maximum period is a reasonable exercise of the limitation clause?
Your Justices, we refer to the fact that we refer to Section 21, subsection 5 of the school's Code of Conduct that states that a public school admits a learner for fulfilling the educational requirements. And Your Justices, that is exactly what the respondent was providing to the learners. A maximum period means that the applicants would still be able to return to school and have effective education. The sole purpose of this Code of Conduct was not to eliminate the learners from the school, but rather so that they could learn from their misconduct.
Thank you, Counsel. I'm now going to allow Justice Gaum to put a question briefly.
Thank you very much. I have more than one question, so they are linked, if you will allow me, Madam President.
Right.
You started dealing with Section 36, which is the limitations clause. So I want to know, does that mean that the respondents accept that Section 4 of the Code of Conduct does limit certain rights? And if so, which rights are those? And then the second question I want to ask is, do you think the Code of Conduct constitutes a law of general application as required by Section 36? And the last question is, don't you think there would be less restrictive means than the means employed by Section 4? For example, they could have indicated you might be in possession of a cell phone. It should just be switched off when you are in class, for example. Thank you.
Your Justices, firstly, we submit that suspension was the less restrictive measure, being that it was just for a maximum period, meaning that the learners would still come back to school. Your Justices, we also state that even if the applicants had a problem with Section 4 of the school's Code of Conduct, it stipulates that, Your Justices, Section 29 states that if any person is aggrieved by the decisions made by the SGB, they are allowed to come to the executive members of the council, of which, Your Justices, the applicant was given the platform to discuss their grievances, but they did not, Your Justices. As they were given the chance to go to the RCL members, they were given the chances to go to anyone if they had any problems with the Code of Conduct. Your
Right.
Justices, the
Counsel, I don't want to rush you, but I see there quite a few more questions and there's little time left. Thank you for that succinct answer. Can I ask Justice Jackie Quisette for your question?
Thank you, Chief Justice. Counsel, I want to ask you another question. I think sorry, am I still on mute?
No.
Okay. I want to ask a question, Counsel, I think linked to Justice Gaum's previous question, and I'm really interested in the application of the limitations clause, assuming this does amount to a law of general application, the Code of Conduct, and the application of the factors that need to be considered by in terms of Section 36. And I'm particularly interested in 36(1)(e), which talks about less restrictive means to achieve the purpose. Here, this clause talks about the cell phone being prohibited, whether on or off, and it's seemingly regardless of whether it's being used in class, whether it's in a pocket, whether it's in a school bag. are there not less restrictive means that could have been used to ensure discipline, yet respect the rights to privacy and dignity and other rights implicated?
Your Justices, we refer to the states given that cell phones cause a distraction to school. And according to Section 8 of the Schools Act, it states that the distraction of school is unacceptable. We state, Your Justice, that Ms. Koza did send a message to the school to discuss if there was any mistakes that were in the school's code of conduct. But regardless of that message and the willingness to reconcile, none of the applicants appeared to this meeting, Your Justice.
Sorry, Counsel, but I want you to address my question specifically. If a cell phone is off in a classroom, it's not on, it's not disturbing anybody in a classroom environment, how is that affecting discipline?
Your Justices, we refer to the fact that it does cause distraction to the point where, in this case, we find that a day has to be dedicated to a random search, meaning that effective education would have taken place. But however, now the school has to deprive from that and actually do a random search, which is the distraction of school, Your Justice.
Thank you, Counsel. Justice Khan Parker, I'm going to give you an opportunity to question the next counsel. We've run out of time on this. Thank you, Counsel. You know, now have your co-counsel.
Thank you, Your Justice. As it pleases the court, I will take my leave.
As the court pleases to remind the court, I am Licheta Jongwe, counsel for respondent. As the counsel for respondent, will be arguing that the SGP's decision to suspend the learners is not unconstitutional and does not violate their rights in terms of Section 17 of the Constitution. Your Justices, the counsel for applicant previously mentioned that the respondent violated their rights in terms of freedom of expression. We submit to this honorable court that it is not so. The applicants expressed their right to freedom of expression through placards labeled cause for COSA. And Your Justices, Section 8, subsection 5 of the Gatherings Act states that no person present at or participating or demonstration shall, by way of a banner, placard, speech, or singing, or in any other manner, incite hatred of other persons or any group of other persons on account of differences in culture, race, sex, and language. Your Justices, we submit to this honorable court that the placards labeled cause for COSA incited violence, as after the placards, Your Justices, a fire, there were beans burnt near the car park, meaning that, Your Justices, it was targeting a teacher, near the teacher's placard, targeting a teacher. And Your Justices, we agree that, Your Justices, the right to Section 17 is paramount, but Your Justices, the applicants must do so peacefully. Section 17 of the Constitution states that everyone has the right, peacefully and unarmed, to assemble, to demonstrate, to picket, and to present petitions. The paramount conditions in this act are peacefully and unarmed. This right diminishes when these conditions are not met. As the counsel for respondent, we submit to this honorable court that since the applicants' gatherings were not peaceful, since the applicants committed several acts of unpeacefulness, which include blocking the school gate, preventing other school learners from gaining access to the school, confrontation with the road users, the right in Section 17 is not exercised peacefully. Your Justices, if it pleases the court, the counsel for respondent act is in line with the deliberations made in the Recital case. Paragraph 53 of this case states, and I quote, "Nothing said thus far detracts from the requirement that the right in Section 17 must be exercised peacefully." And it is important to emphasize that it is the holders of the right, in this case, the applicants, who must assemble and demonstrate peacefully. It is only when they have no intention of acting peacefully that they lose their constitutional protection. Close quote. And furthermore, Your Justice, in paragraph 103 of the Mlungwana case, it was held, and I quote, "Therefore, to criminalize the convening of a violent or armed gathering would be constitutional, as such gatherings fall outside the ambit of the right in Section 17. Close quote. Your Justice, as the counsel for respondent, we submit to this honorable court that since the applicant's rights were not peaceful, they fall outside the ambit stipulated in Section 17 of the Constitution. Furthermore, Your Justices, The violence that erupted during the protest convinced by the applicants violated the respondents' rights in terms of Section 12 of the Constitution. Subsection 1 of this section states, and I quote, "Now, everyone has the right to freedom and security of the persons, which includes the right to," subsection C, "to be free from all forms of violence from either public or private sources." The violence that erupted, your justices, in the gatherings organized by the applicants violated this right. And your justices, the applicants mentioned that they should not be held liable for the violence that occurred. Your justices, to quote from the Mlungwana case in paragraph 22, it is stated, and I quote, "A convener can be held liable for any riot damage caused by a gathering or demonstration. This liability is civil in nature. The convener is presumed to have acted unreasonable if the riot occurs as a result of that gathering. But this presumption is rebuttable if the convener can show in essence that the riot damage was not reasonably preventable and foreseen, that they can avoid liability," close quote. Your justice, in this case, we submit to this honorable court that the riot damage was foreseeable. The Council for Applicants and Justices may argue that in the first gathering, it was not foreseeable. But after the justices in the first gathering, there was violence. They should have foreseen in the second and third gathering that the same violence might erupt as it pleases the court.
Right, thank you, Counsel. Your protection time has elapsed. I'm going to give Justice Sibanyoni an opportunity to pose his question to you. Justice Sibanyoni, I don't know if I must read out the question, or are you able to unmute yourself? I think there's a problem with Justice Sibanyoni's audio. The question is the following. Does the SGB to make such a code of conduct without consulting the parents? Can the code of conduct be made without consulting the parents? That's the first question, and then I'll put the second one to you.
Thank you, Justice. Your Justice, in this case, the SGB did consult the parents, because in the facts it is stipulated that after a consultative process, the SGB decides to implement Section 4 of the School Code of Conduct, if it pleases the court.
Now, the second question, and that's an important question, if the cell phone is confiscated, why is it still necessary to suspend the learner? It's almost as if it's a double punishment, is it not?
As it pleases the court, in this case of justices, firstly, it was stipulated in the text that many teachers found it disruptive because learners were on social media. We submit to this honorable court that even though the cell phones were confiscated, a suspension was needed in order to make sure that the learners actually learn from their mistakes. And if it pleases the court, the learners, the suspension in this case is a less restrictive measure, because before Section 4 of the School Code of Conduct was implemented, there was much resistance against the previous measures used, if it pleases the court.
Thank you, Counsel. Further questions from the justices? Justice Garm and then Justice Valley. Justice Garm, unmute yourself.
Sorry, there I am. Yeah, it seems that you are suggesting that the protest action actually incited violence. Can you, in terms of the facts of this matter, point us to evidence in that regard, please? That is my first question. And then I also want to, the applicants referred to what they are saying. There's clearly no link between the 6 who were suspended and any violence or the fire or the disruption of the schooling and so on. Can you deal with that matter? And also with the point that they raised that the other side was not heard, so the audi alter partem principle was not applied before these 6 learners were suspended. Thank you.
Thank you, Justice. To substantiate our answer, Justice, is that the applicants incited violence. The justices, after their placards labeled cause for causa, immediately after so a rubbish bin burnt near the school teachers' park. The justices, to deduce from this, Ms. Koza is a teacher. Therefore, Your Justice, they incited violence because after the cause for Koza, immediately after fire burnt near the car park, it's describing that the teacher was a mere target. Ms. Koza was the target, if it pleases the court. And Your Justice, to answer the second question that there is no clear link between the violence and the learners, Your Justice, in Lungwana case, Your Justice, it is stated that if a convener can be held liable for any riot damage caused by a gathering or demonstration, the convener is presumed to have acted unreasonable if the riot occurs as a result of that gathering. But this presumption is rebuttable if the convener can show in essence that the riot damage was not reasonably preventable and foreseen, but then they can afford liability. Close quote. Your Justice, in this case, we submit as the counsel for respondent that the riot damage was foreseeable. In the first gathering, Your Justices, they were the first time they were gathering, riot damages occurred. In that case, they have not foreseen so. But in the second and third gathering, the applicants should have been prepared because in the previous gathering they gathered under, there was violence. So they should have set up safety measures to prevent any further violence or damage to the state property from occurring. If it pleases the court.
Thank you.
May I just to follow up quickly, but the convener is only one of the 6. What about the other 5?
As it pleases the court,
their liability.
Clarify, Your Justice.
Could you just repeat the question, Justice Gown, for clarification?
No, I say that you referred to the convener that can be held liable for a riot as a result of the protest, but the convener is only one of the 6. What about the other 5 and their suspension then?
In this case, Your Justices, all of them are conveners because they planned the gathering together, if it pleases the court.
Thank you, counsel. Justice Valley.
Thank you, Chief Justice. Section 14 is very clear in terms of the right to property, right to privacy. It says no one has the right to have their property searched or seized. But in this particular school, they can search anyone at any time and seize their property at any time. How do you justify this?
Your Justice, we call from the regulations to prohibit initiation practices in school government notice 23315 established under section 61 of the Schools Act, which deals with public safety measures in public schools. In 3.2.2, it is stated that every learner has the right to privacy, which includes the right not to have his or her homes or property searched or his or her possessions seized. Notwithstanding this, the principal or an educator may search learners based on his or her personal suspicion that the learner is in possession of an illegal object, using such methods that are reasonable in scope. Your Justices, in this case, an illegal object is, in this case, the Gazette did not define an illegal object. But Your Justices, cell phones are illegal in the school. Therefore, it was just for the principal to search the learners. And in the same Gazette, Your Justice, a warrant is not stipulated as a condition, as it pleases the court.
Sorry, if I may follow up just very briefly. Sorry, Chief Justice, I won't be long. Where is the reasonable suspicion? Once the phone falls out of the pocket, the whole class is searched. Thanks.
Just after Spisok's phone dropped out, it raised an enough reasonable suspicion because previously cell phones were found to be disruptive. So in order to protect the learning environment of the school, they had to search the learners to find out are there many other learners who try and endanger the discipline in the school as it pleases the court.
Right, counsel, one last question. Justice Khan Parker.
Thank you, Chief Justice. And it relates to what happened immediately after the learners were released by the police and diverted into a diversion program. Counsel, Ms. Koza then sends out a message and then effectively calls an urgent meeting and decides to suspend for the maximum period the 6 learners who were arrested. Is this reasonable? Is this reasonable conduct for a school governing body or a school in terms of how it relates to the right of the child to have education. Thank you.
As it pleases the court, as the counsel for respondent, we submit in this case that it is reasonable. Your justices, the applicants committed several acts of serious misconduct. Firstly, they brought cell phones to the school, and lastly, your justices, during their protest, serious damage to the school property was incurred by the school. Therefore, your justices, in this case, the school was just to suspend the learners for the maximum period as stipulated in the Schools Act, if it pleases the court.
Thank you, counsel. I'm now going to ask your co-counsel to make submissions.
If it pleases the
co-counsel,
if it pleases the court, may I get a minute to finish my arguments?
Right, you know, time is of the essence in the Constitutional Court. How much time do you need? 1 minute?
Yes, Your Justice.
Yes, 1 minute, counsel. You may continue.
Your Justice, Section 3 of the Regulations of Gatherings Act 205 of 1993 states that a convener of a gathering shall give a notice in writing by him. To remind the court, the applicant was suspended because of the second and third gathering.
Sorry, have you frozen? Counsel for respondent, I think your audio has gone off, has muted itself, or else you've frozen. Mr. Mateus and the bailiff.
Madam Justice Victor, I think they are frozen. I did stop their time on the bailiff's side. They have about 36 seconds left. I'm not sure, it could be because of a power cut on their end as well. That is quite a possibility. However, that was from the, I think they're back now, perhaps the respondent, hello?
The respondent.
Sorry, just a recent electricity cut. May I continue?
Yes, there you go.
Your Justice, Section 3 of the Regulations of Gatherings Act 205 of 1993 states that a convener of a gathering shall give a notice by him of the intended gathering in accordance with this section. Your Justices, to remind the court, the applicants were suspended because of the second and third gatherings. Your Justices, even though the applicants argue that their first gathering was spontaneous, their second and third gatherings were not spontaneous as the applicants gathered at Precious House to plan the protest. Taking this into account, your Justices, the applicants certainly knew that they had the same common grievances as other school learners. Therefore, your Justices, they should have foreseen that since they have the same common grievances, other school learners are going to join in the protest. Taking this into account, this knowledge cancels the assembly as a demonstration and makes it an intentional gathering that requires a notice. In summary,
right. Continue, make your summary, and that's giving you 30 seconds.
In summary, we have, as the counsel for respondent, we have shown the following: that Section 4 of the School Code of Conduct is constitutional and does not violate the applicant's rights to basic education and privacy, and that the SGP's decision to suspend the learners is constitutional and does not violate their rights in terms of Section 17 of the Constitution.
Right.
As such,
your time is up. Your time is up. And I must commend you for your resourcefulness when the electricity went down. You're obviously on your phone now. Right.
Thank you.
So I could hear co-counsel.
As it pleases the court, it is for these affirmative reasons the counsel for the respondent requests this honorable constitutional court to declare that the courts of core were never inaccurate for ruling in favor of the SGB, as it only sets decisions that do not violate the applicant's right to peaceful assembly, basic education, and privacy.
Thank you for that summation, counsel. I now turn to the applicants. The applicant to reply. Is there a right of reply, Mr. Mateus?
Justice Victor, we have 1 minute, 30 seconds for the applicants to reply. Thank you.
Right. For the applicants, just a moment. Also bear in mind that you've got to deal with the question of costs if you are successful,
Okay, my justices, we have 2 points to rebut on. We will refer to the fact that the counsel for respondent stated that was talking about violence that was caused by the applicant. We remind this honorable court that our applicants were not found to be the ones to be causing the violence, as we could refer to Article 21 of the United Nations International Covenant on Civil and Political Rights, which informs us that an individual does not cease to enjoy the right to peaceful assembly as a result of sporadic violence or other punishable acts committed by others in the course of the demonstration. And my justices, the counsel for the respondent stated that there was no notice given. We would now like to remind this court of the Mulungwane case, which clearly informed us that it had been proved that a notice is no longer really necessary to be given for it infringes upon the learner's rights to peaceful assembly in terms of Section 17 of the Constitution.
Thanks. And just on the question of costs, are the applicants seeking a costs order if they are successful? A question by Justice Sibonyoni.
We submit that the court should find or declare the High Court as correct. Secondly, we submit that the Section 4 of the Schools Code of Conduct was unconstitutional, and as well as it violates the learner's right to privacy and basic education. And also that they should strike out Section 4 of the Schools Code of Conduct, as it is not.
Councillor, I only wanted you to deal with costs, but thank you. You did mention costs of the application. Thank you. You may be excused. Right, Mr. Mateus?
The Honorable Court is now adjourned. The judges shall be excused to deliberate. Thank you.
Court will adjourn.
Thank you very much, everyone, for being here today. We will now allow the judges to go and deliberate. Judges, please exit this room and join me in Court A as you deliberate, as well as you hand over your scores. And we will be back, I think, in about 15 to 20 minutes to announce the results. Thank you.
How do I put up my hand?
Are you going?
Good morning, everyone. We are now taking an official break. We will be back at 25 past 11 for the judges, after the judges' deliberations for their decision. So we can take a comfort break in the main room or from the main room. Thank you.
We, the people of South Africa, recognize the injustices of our past. Honor those who suffered for justice and freedom in our land. Respect those who have worked to build and develop our country.
I'm delighted by the way it went this year. It's the first year where we have two new elements. The first one is that the mood problem was prescribed at school level, so in the subject English, the learners had to write as part of their essays, they had to write for the applicant and for the respondent. And that really gives it much broader scope than before, so it reaches thousands of people. And in the second place, the Human Rights Commission is on board. And I think that's very significant as well. The Human Rights Commission is ideally based to do this as human rights education. It's also not the individual university who tries to do it, but as a neutral institution, it can collaborate with all the universities in the country. So I think the involvement of the Human Rights Commission has been tremendous. Today was a big success. It was a pleasure to do it with the Human Rights Commission. And I think also in the future it will grow because of this. Many more universities will become involved. Students will coach at schools. And so I think this will grow.
We as a commission, we are very proud and happy about our association in this school mood competition. It definitely has a great potential to help to broaden the understanding of human rights in our schools, but also advance the culture of human rights in our country.
As Eleanor Roosevelt said, one of the pioneers of the Universal Declaration of Human Rights begins at home. And I think the young people today have shown us how they can really be actors of change when it comes to human rights literacy and advocacy. I have left this place feeling really a sense of renewed inspiration about the work that we are here to do in uplifting the Constitution of South Africa and the universal human rights values.
The Schools Moot Court is one of our flagship co-curricular activities that links into the English curriculum and helps all learners countrywide to learn how to argue for and against a particular position related to the Constitution. And today, as we saw in the court, the children really made us proud. Each and every single one of the respondents and the applicants shone.
I believe that that for us to live up to the ideals of our Constitution, we must accept and celebrate diversity and difference. But it's more than merely accepting it. We must truly embrace and celebrate the diversity of those around us. I think Judge Albie Sachs articulated it beautifully in the Fareed judgment when he said, and I quote, "South Africans come in all shapes and sizes. The development of an active rather than a purely formal sense of enjoying a common citizenship depends on recognizing and accepting people with all their differences as they are."
What impressed me is that they were able to think on their feet. Whenever we were asking them questions, they were able to give responses to those questions and the like. A code of conduct that stipulates that only Christian religion will be allowed and no other religion. How would you respond to that question?
Your Justice, that in itself proves the unconstitutionality of a code of conduct. And this was further enhanced or emphasized in the God case that ruled that no school could adhere to and promote one religion to the exclusion of others, like it has in this instance.
At a practical level, was the applicant given a hearing before the school board, governing board made its decision?
As this court pleases, it stipulates in the facts that the SGB did take the decision to suspend the applicant after following all proper procedures. So the answer to your question, Your Justice, is yes.
I've really enjoyed this competition. It let me get a very good sense of what the law is like and got me a lot closer to the Constitution, which I think is incredibly important for a lot of learners in South Africa. It was also very interesting because we got a lot of really interesting feedback and we learned a lot about how to improve our argumentation, which is something I think is valuable. I've enjoyed this experience a lot and I've enjoyed working with all of the new people. I enjoyed working with my partner, but it was also very nice to meet new people and have new experiences.
The competition has taught me a lot about knowing your rights and responsibilities and knowing how to protect yourself from being discriminated against. And also it has been such a learning experience in terms of meeting people who can help you to understand the competition even more.
This competition has been a great experience as we learned so much about the Constitution, provincial legislations and all those laws that make our country a democratic country. Since I've entered this competition, I've had a lot of interest in law, so it's been a great interest and I'm really proud of me and my co-counsel that we've made it to the semi-finals even though we didn't win, but then it was still a great experience.
Moreover and above, not only does it only assist you with making career decisions, but it also shapes you up as an individual human being. It shapes your perspectives and it allows you to be able to engage with the law, which I think that in its own self is a promotion of positive citizenship in South Africa and is quite essential in our new democratic South Africa.
We want active citizens to come out of this exercise, and in whichever capacity we're going to have a richer society. So I'm quite confident that we have started something brand new, but something that we can be very proud of as well.
Good day, everyone. I'm just appearing quickly just to let you know that the judges are still deliberating. They are finalizing their deliberations. So as soon as they're done, we will return back and obviously have the announcement of the winner and close today's proceedings. Thank you so much. Good day, everyone. Thank you. We have just received word from the judges during their deliberation that they will be back in the next 5 minutes. So within the next 5 minutes, we will reconvene. And at that stage, that is, of course, when we will have the announcement of the winners, as well as the prize giving. The vote of thanks, of course, by the CEO of the South African Human Rights Commission, and that's Advocate Sirisoti Panyani. And at that stage, that's when we will close proceedings. So it's another 5 minutes before we finally find out after hearing great argumentation, who the final winners are. Thank you. Good morning once again and welcome back to this final round, this grand finale round. And of course, everything has been wrapped up. We've heard wonderful argumentation being presented in front of us today. And with that, I think that there's only one thing left after the judges' deliberation, and that is, of course, the announcement of the winners as well as the prize giving. And to let us know, and also to give us the judgment as well as the deliberations of the court today, is of course none other than the Chief Justice, Margaret Victor. Over to you, Chief Justice. Thank you.
We as judges have conferred, we've deliberated. It was a very difficult task, but what we do conclude is that we can sit back, we as senior practitioners in the legal profession, we can sit back and know that the future of law is in good hands, and also that the rule of law is in good hands. Our understanding of your arguments, your application of the facts to the law, and in particular to the constitutional law, the international law, we are really reassured that the future is in good hands. We also know that we're entering a different world of virtual platforms. And I was amazed, and I must commend again how I think it was the respondents who, when the electricity outage happened, they were so good about going straight onto the telephone. And we must commend that. Some years ago, I gave a talk at the Johannesburg bar to a dinner. And I said that the future of law is very much going to be digital in the future. And I quoted the work of Richard Susskind. Perhaps you want to make a note of that. Richard Susskind, a professor of law from Oxford University. And indeed, now 5 years later after that talk, we see that we're truly in the digital era. The pandemic has made us pull out all the stops. And in Johannesburg, virtually everything is now done on the virtual platform Teams. And of course, we can't do that for the criminal law. There we still need in person. And I think that even after the pandemic, once we've completed all the waves, I believe the next wave is coming, there will still be a lot of matters that are heard virtually. It also saves costs, as you can imagine, if counsel, I think you're from all over, but imagine if you have to all come to Johannesburg to the Constitutional Court, it involves a lot of costs. So this virtual platform has reduced legal costs and made it easier for access to justice. What impressed us is the tremendous hard work that went into your preparation. And it's just very difficult to really assess and see who is the winner. You were all so close. Your ability to speak publicly, your analytical skills, all that came through so carefully. And it seems to me that the importance of this competition must not be forgotten. In fact, there should be more emphasis on this competition, because not only does it involve schools, but it also involves the rule of law, and that you as participants are really the ambassadors going forward for the rule of law, for commitment to the Constitution, commitment to international covenants that must be interpreted in terms of Section 39 of the Constitution. I was most impressed with how easily you moved from quoting the Constitution to international covenants to regulations, and that was all very impressive. So again, each one of you must be commended. There always has to be one winner. But let me say this, the difference between the two teams was only 3.5%. And that took a lot of soul searching and a lot of deliberation. So I'm very pleased to announce the winner The respondents are the winners of this year's moot court competition, and the difference was very slight. Right. The court will adjourn.
Gotcha.
Adjourn. Mr. Matthias.
Thank you very much, Madam Justice Victor. The court is now adjourned. Congratulations to both finalists. Congratulations for the respondent for taking this one last round. I will hand over back to Mr. Gashwal, the program director, to direct us on what is the next thing on our program. I think it is the awards giving time, which would be done, I think, by Sis Joyce. But Mr. Gashwal, please redirect us. Thank you very much.
Thank you so much for that, Simon. And of course, thank you to the Chief Justice, Margaret Victor. And well done to both teams in their participation in today's competition and for doing so well. Of course, I'm sure that you would like to know who, there's many participants and the process is quite extensive, as you're well aware, starting, of course, with the essay, culminating in the provincial oral rounds all the way through to this the final rounds at this national level into the grand finale, which we witnessed today. But to start things off, best overall essay was by Paul Roos Gymnasium, and the two learners there was Michael Sampson as well as Jordan Cridland. Well done to you on that, and your trophy you will be receiving your trophy soon. And on that basis, well done. I can see a digital round of applause being given. Joyce Clow, my colleague, is holding up the trophy. If you could just bring it down a little bit so that it can be seen. This is the trophy for best overall essay. Well done on you. Thank you so much. The next category is for best applicant essay. And again, from Paul Roos Gymnasium is Michael Sampson as well as Jordan Cridland. Well done to the two of you. This is for best applicant essays for this year. Well done to you on that one. And who knows, maybe the two of you can split the two trophies, one taking, each one of you taking one. The next trophy is for the best respondent essay, and that is, of course, for Hermanus High, and that was by Marley Snyman, as well as Lisa Kanya Mklinjana. Well done to you on that. This is for this is, of course, for best respondent essay. You'll be receiving your trophy soon. And then the best oralist went to Bertha Mutsakani from Mowat Park High School. And well done to you for receiving the award for best oralist. Well done on that one. Thank you so much. That rounds up the prizes for this morning. And congratulations yet again, both to the best team. Obviously, the best team in this instance was the respondent team, which consists of two schools. That is Mida High School, which was Team 101, as well as Mowat Park High, Team 214. This is, of course, for the winning team in the 2021 edition of the National Schools Moot Court Competition. Well done on you. Each one of you, each individual will be receiving one of these trophies. Well done on you for that. And a round of applause and congratulations for that. Of course, as you heard, the applicant team was the runner-up in this grand finale. And that is made up of two teams, Team 115 being Makedama High, as well as Team 216 being Mbilwi Secondary. Well done on you as the applicant team. Each one of you will be receiving this runner-up trophy for the 2021 National Schools Moot Court Competition. Well done for you on reaching the grand finale. And not just entertaining us, but giving us an insight into your deep understanding of human rights and everything else related thereto. That brings this wonderful event to a close. And with it, the final word that we will be hearing literally a couple of seconds before we reach this afternoon on the 10th of October 2021 is, of course, the CEO of the South African Human Rights Commission, that is Advocate Tsiriso Tipanyani. Good afternoon to you, CEO, and thank you for joining us.
Good afternoon, Geshwal. I'm a victim of load shedding here, so I hope I'll still manage to survive. I would really like to start by thanking everyone who has taken part in this event on behalf of the South African Human Rights Commission, the Department of Basic Education, and the Department of Justice for this very important event, which I would really like to refer to it as a nation building in motion and in practice, in the sense that, this event clearly contributes, as it has been said earlier on by other speakers, to the strengthening of our constitutional democracy, the respect for the rule of law, and the respect for human rights. But more importantly, for me, an event which really helps, in developing, training, and encouraging future champions and defenders of our democracy and human rights. And who knows, maybe even future judges, chief justices, future presidents, and future human rights commissioners as well. So it's definitely a very important event, which we are glad as a Human Rights Commission that we are part of, and that we also need to do more to make sure this event gets better and better with time. So coming to specifics then, I would want to first and foremost really thank Justice Margaret Victor and a team of panelists who really played an important role at this last stage in facilitating this last round, and of course identifying for us the winners. I also want to thank our partners, apart from the two departments. We also want to thank colleagues in the Center for Human Rights, as well as the Foundation for Human Rights, for their support all along for the past 10 years to get us where we are today. I would also want to thank our colleagues in the Human Rights Commission, Joyce and team Gashwell as a program manager, program director, as well as our colleagues in the provinces and the office of the COO, who also helped in preparing the learners for the earlier rounds up until we got here, as well as of course from colleagues in the Center for Human Rights and Foundation for Human Rights, who also assisted in this event, as well as the other service providers who have also made it possible for us to be here. And then last but not least, I want to thank the learners who took their time, took a lot of effort, to prepare to be here. Thank you, thank you, thank you. But I also want to thank the parents and the guardians of the learners who also allowed the learners to take part in this event, as well as the educators, whether it's the teachers or the principals or the school governing board, for allowing this to happen. And I'm really hoping that, there will be increasing support for this event, and maybe at some point in time, we'll actually be occupying prime time on our media houses so that we can showcase, what could happen, and also encourage other people to take part in this event. So I really want to thank everybody for this event, and of course, the Department of Justice for, again, helping us with the judiciary and many other things. So really, from the bottom of my heart, I'd like to thank everybody, and wish everybody a happy weekend and safe traveling wherever you're going. Thank you. I hope there's no one I've forgotten, Gash. Otherwise, I'm in trouble. Thank you.
Thank you, CEO, and really much appreciated for your note of thanks. Of course, we wouldn't have been able to do this. Obviously, there was a partnership between the South African Human Rights Commission, the Department of Justice, the Department of Basic Education, but I think we have to really thank our team behind the scenes, our digital team, for the exceptional work that they've been doing. I've been looking at the WhatsApps and the emails coming through at ridiculous hours of the morning behind the scenes. So really much appreciated for that. I need to also, of course, make mention of the fact that all participants will receive their certificates of participation in the 2021 National Moot Court, National Schools Moot Court competition. So for all participants, you will be, you will be receiving your participation certificates, of course. The educators that were also part of this particular process need to be mentioned and thanked for their contribution, because, of course, without your assistance, many of the young people would not be able to assist in dealing with this, as well as our judges, our panel of judges that have come through volunteering their time this morning to assist, and really much appreciated. Thank you again, CEO. You've made mention of everyone there that's relevant, and it was an absolute great pleasure for me to be, of course, your Master of Ceremonies / Program Director throughout this particular process. All the best to you, and to echo what the CEO had said, have a wonderful weekend.